submissions pertaining to Mr. Makaleni, correct all the typing errors. We have since done that. It's nothing new, my lord. We just a separate document, and I've given a copy to my to my colleagues. It's okay. In essence, it's the same document. The only difference, my lord, is there was a lot of unhappiness from my colleagues that we are introducing something new. It's nothing new, my lord. We're saying that the evidence of Makaleni is on record, that in considering the evidence in this matter, the court should also consider the evidence of Makaleni, and we're saying what the legal basis is for the consideration of the evidence, namely that by introducing the document, they agree to the hearsay evidence. Alternatively, in terms of the interest of justice test, that the evidence be allowed. That's all that we say, my lord. Nothing new. It's already on record.
To object, my lords, to this so very unknown procedure. The issue, my lord, in this application, or the issues in this application, are specifically defined. There's been an application by accused number 4 that on the basis of the fact that the state has not been able to establish a prima facie case against him on all the counts, he requested the court that he should therefore be discharged at the close of the state's case. The states respond, the manner in which they've responded. That is the issue that needs to be determined at this point in time. Now the state stands up, and it is struggling. It's very struggling. It stands up and say, no, but there's a Makaleni issue. There's the record of the transcript, my lord. What do those submissions have to do with the application that is so circumscribed, that is so specific? And I've indicated on Tuesday, my lord, that the state, if it feels like there is something that they have missed in the presentation of their evidence, which I would refer to as struggling, they would still have the opportunity. There is nothing wrong in terms of the procedure for them to stand up and say, my lord, we acknowledge the fact that we had already closed our case. But there is information that we feel, in our view, that would be the state saying that we can use at the end of the state, at the end of the close of the case, to make an argument that will supplement our application for a conviction. Then the court will have to make a decision on whether or not it grants them that leverage or that allowance or that indulgence. But not now, my lord. Because if I were to stand up and start to address the issues that the state is now raising, this procedure will be very precarious. It will be unheard of in any civilized legal system, particularly in a system that is codified. And ours in South Africa is codified in terms of this Criminal Procedure Act number 51 of 1977. Such procedure is not allowed, my lord, particularly when there's an application in terms of section 174. This section must be dealt with and be finalized. Then the state, as I've said, if they feel there is something that they need to add into their struggling evidence, then they can stand up and say, no, we also want to add this another struggling point in our struggling evidence through an application. The state does not even apply now. It simply says, we also want to add this, we also want to add this into the record. What is the purpose of this sitting, my lord? Is it to introduce new evidence or to make a determination on whether or not accused number 4 has been able to bring to the court an argument which in the mind of the court says that it should be discharged, or the state which in the mind of the court says accused has not been able to discharge the honors in terms of Section 174. Those are the issues at this point in time, my lord. Otherwise, the procedure that is being followed here, Fiasco does not even begin to explain it, my lord. It's unheard of.
Yeah, fine. I've heard you. You see, the problem with you and your colleague arguing, you discuss things in my absence, and then you want me to solve them. You see, he says, you approached him. I wasn't there.
No.
And you complained about A, B, C, D, E, F, G.
No.
And now he says he's rectifying what you complained about. Am I correct, sir?
That's actually, it happened here in court on Monday, as he says. That's why they said
Now
that,
I'm being blamed for not knowing the procedure.
yes.
No, my lord. I am not saying the court does not know the procedure. But what I'm saying is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord. Now, the issue is, my lord, there are issues which have been raised here. And the procedure at which we are now, which is an application in terms of Section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence.
Okay, so are we...
Through the back door, my lord. Well, I don't know if this procedure, if the court really affirms this procedure, I'm in the hands of the court.
Don't talk about the procedure, because I'm telling you what you do in my absence.
No, but my lord, there was no agreement. There is no agreement that
But you spoke to him.
About what, my lord? We spoke to him about what?
Okay, fine. That's it.
I never speak to the state, my lord, because I know the way in which they operate. Everything that I do, I make it a point that it is done on record. I know the way in which they operate.
As we pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions. We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We putting on record what ought to be considered. I don't understand the objection by my learned friend. Nothing, no new application. We're just saying the court, as we have done, we have summarized the evidence. These are aspects that we could have mentioned in the summary of our evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary. Nothing new, my lord.
Yes, Mr. Norman. Are you through too?
My lord, I'm not in a position to respond because in respect of the statement of Makaleni, the 7 requirements in terms of the Act have not been met. I've never heard the state discussing the issue of the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, and the property value of the evidence of that statement. In fact, my lord, in my address...
You're not quoting the SC, the Constitutional Court case of Darcy. Are you not quoting that case, sir?
No.
Yes, the one that we quoted, my lord, it's Kappa.
Because it is the...
Kappa.
Yeah, it is the Constitutional Court speaking there. It's not the...
The Act speaks.
Yeah.
The Constitutional Court refers to an Act. So
Yeah.
when an application is made, the 7
It's a
requirements...
judgment of the Constitutional Court. What more do you want me to say?
Yes, I know that.
And he's reading that judgment.
Yes.
And that judgment says there are 7 categories which must be satisfied.
Yes. Yes.
So what is the problem?
Has the state satisfied those requirements?
I don't know if I'm saying that judgment, as I understand it, that's what it says.
I understand, my lord. Further to that, in my application, I never refer to the statement of Makaleni. So how does it find its way through this court in this application?
Yeah, fine, you can argue that if you want to.
Because, my lord, I've referred this court to the case of Mkedezi to say that for the 5 requirements, they must be met for my client to say he formed common purpose with the others. But now the state is referring to the Makaleni statement, of which I never referred to Makaleni, as to how Makaleni and accused number 4 is related in respect of this application that I've dealt with.
Yeah, you can argue that I must reject that argument.
That is my argument, my
fine.
lord, that I respectfully ask the court to reject that evidence.
Yeah.
It finds no application in the application that I've made before this court on the 25th of August. That was
Okay.
on Monday.
Sorry, my lord, may I perhaps find clarification? On Tuesday, when the issue of Makaleni reared its ugly head, Advocate Munisi stood up and inquired from the court whether, because of that Makaleni issue, which was not canvassed in Advocate Ngumalo's application, and it does touch on particularly Mr. Ntanzi. And further, my lord, regarding the manner in which the response by the state seeks to have the extracurricular statements of accused number 2 apply to all accused persons that are before court, which is anti the Mhlongo case. So on that basis, Mr. Advocate Munisi asked whether we will be afforded an opportunity to reply, and the court confirmed that we could reply. Hence, in the morning, I was asking, is that procedure? Because those are fundamental issues in this application, my lord. It has escaped the circumscription for the application and the reply. Now we are in Swana. We are touched by blood that was not meant for us.
You know what? If you guys apply the law, and you know the law, there won't be problems. If he knows the law and he applies it, there are no problems. If he does the same, he applies the law and does it, and he argues, and you say, I must write a judgment. I'll write a judgment because I know the law.
Yeah, because we found ourselves perplexed.
So if you want to supplement your heads, you can do it, no problem. If you think it's necessary.
My lord, I stand as an officer of the court because I did not per se make an application, but if I see issues that I feel as an officer of the court that things are not going well, my lord, I should stand up and ventilate and assist.
I can tell you what is your problem.
Yes. What is my problem, my lord?
If you read that charge sheet,
Yes.
it says the 5 gentlemen there are charged in terms of section, common purpose, and then it's section 51 what?
It's 51.
Just read 51.1, because that is the problem, I can tell you now. Jesus.
51.1 is more of minimum sentence.
Yeah, the conspiracy part. They don't charge with conspiracy.
Well, we do mention in the indictment that
To say?
that charge in terms of common purpose and or conspiracy, but
In the indictment.
yes, in the indictment.
I think that is the problem. Eh?
Yes.
As I understand the law, if you are charged in terms of a common purpose and a conspiracy, it applies to, according to the state, not me. It applies to everybody who's charged.
My lord, 51 deals with sentence.
No, he says it's not. He says he mentions it as a
Yes.
conspiracy.
Yes.
Okay,
Yes.
that's how I understand it.
Because, my lord, for me, the concern is this Makaleni issue. The procedure that I know is that before the close of the state's case, the state, if it wishes and intends to lead or to have the court admit hearsay evidence, it stands up and makes an application to the court to say, my lord, we've let hearsay evidence, for example, of Makaleni, and we are making an application for that hearsay evidence to be admitted. And both the parties, the state argues the admission and we argue against the admission. And the court makes a ruling. Now we are stuck here where these things enter via the back door.
I only make a ruling when I deliver the judgment.
Yes.
Not before.
Yes.
Okay. I listen. Before then, I listen.
Yes.
If he misquotes the law, I just listen.
Okay. Yeah, because that was my concern, that the law was
So
quoted.
if you and Mr. Ngumalo say there is no law like that in South Africa, fine.
Yes, because
I can tell you there is a law like that. State S versus Roll.
a law like what, my lord?
Wait. There's another one also where this judge, and he's a very experienced judge, it's I think it's Falam. Falam was handling a case in Joburg. The state and the defense argued, and they closed their case, both of them. And then Falam made an order that there should be an inspection in loco held, because there is an aspect which he wants to examine at the scene of the alleged murder. And it did that.
My lord,
No, I'm telling you that
yes,
this
yes.
is
But
something
before
new.
I sit down, my lord, let me just also refer to the law, my lord. The infamous Indlovu SCA judgment case, the one that was overturned.
Yeah, by Goldstein.
Yes.
He used to sit in this court with me.
Yes. Where
Goldstein.
Judge Cameron, my lord, and I just want to read this paragraph, and then perhaps we can engage with his lordship.
He wrote
further.
the appeal.
Yes.
Goldstein wrote the judgment in Joburg,
Yes.
and then Cameron, when he went to the SCA,
Yes.
he handled the appeal.
Yes. And the case law, my lord, I can argue Kappa and say Kappa
Okay,
is
are you through,
opposite.
sir? Because I thought you were through.
Yes.
Yeah, fine. Ready. Okay, let's meet on Tuesday then.
Made on
10 o'clock Tuesday. The judgment, or ruling as you call it, will be delivered then.